Environmental Health Trust. He's going to give us a general roundup of the legal challenges around the 5G deployment in the United States. Edward, can you hear us?
I can hear you, yes. Can you hear me?
We hear you fine.
Great. I'm trying to upload my slides, and I'm having a little difficulty with that, unfortunately.
If you open them on your station now, we can see you. We have you shared. So just simply open them on your computer. No need to upload. Just let us see them on your computer.
Okay, very good. So you can see my slides right now?
We can see your screen. You're sharing your screen at the moment. So just simply open and we'll be able to see them.
Okay. Great. There we go.
Yeah, we see it fine.
Okay, great.
Can you see us, by the way?
Yes, in a very small box,
Yes.
but I can see you, yes. Okay. So my topic is evolving legal strategies dealing with contending with wireless technologies in the United States. I am an attorney in the United States. I've practiced law since 1977, and for most of those years, my practice has focused on federal regulatory issues. In 2018, I intervened in my personal capacity in the appeal of an FCC order challenging an order of the FCC that had attempted to exempt all small wireless facilities, so-called small wireless facilities, and we're talking about 5G cell towers, from any environmental review. Working with the National Natural Resources Defense Council, we were able to get the U.S. Court of Appeals in the District of Columbia to overturn the FCC's order. Currently, I'm representing the Environmental Health Trust and several other petitioners in the appeal of an FCC order terminating a proceeding that was likely to have updated the FCC safety standards. And I think some of your previous speakers, Dr. Razi and others perhaps, referred to that. This was the chance to get the FCC to take a hard look at current technology and adjust its standards accordingly. But for whatever reason, the FCC decided that they were satisfied with the standards in place, and they terminated that inquiry. So we are now in the U.S. Court of Appeals for the District of Columbia again. There's another group in another Court of Appeals, the Ninth Circuit, and we're all waiting for orders from the court to establish a briefing schedule and to move forward with that appeal. We're hopeful of convincing the court, based on a wealth of data in the record, that the FCC was, again, what's arbitrary and capricious, which is the legal standard, for showing that they lacked any reasoned decision-making in drawing the conclusion that they did not need to update their standards. I'm going to give a little background regarding the problems that we are facing in the United States, give you an overview of the problem. The U.S. government is attempting to expedite the adoption of wireless technologies without any regard to the health, safety, or environmental impacts of the technologies. They appear to have been captured by the industry, which is not the first time a regulatory agency has been put in that position, unfortunately. The U.S. government has preempted, through a number of laws, the traditional authority of local governments to control land use in their jurisdictions. The U.S. government also has disregarded the chief environmental laws, including NEPA and the National Historic Preservation Act. These are the laws intended to protect the environment from undue impacts and impacts on historic and cultural resources. And I'll return to this subject shortly. The U.S. government also has failed to develop adequate health and safety standards to deal with radio frequency emissions, as I'm sure you've been discussing this morning. Traditionally, the breakdown of governmental authority in the United States reserved the authority over land use to state and local governments. This made sense in the United States, given the size of the country, and it developed historically from the fact that the individual state governments were organized and well established prior to the establishment of a national government. Naturally jealous of their prerogatives, the states ceded only so much authority to the national government when the nation was formed. Land use decisions were left to the state and local governments. And this has largely remained the structure for land use planning in the United States to this day. In consequence, even today, local governments typically exercise control over land use planning through zoning boards and planning commissions and such organizations. Local citizens have a great deal of sway accordingly in such land use planning decisions. Nevertheless, there has been federal legislation that affects how land use planning decisions are made. And as I referred to previously, this includes the National Environmental Policy Act, or NEPA, and the National Historic Preservation Act. NEPA requires federal agencies to conduct a review of how major actions would affect the human environment. Typically, if a action may or may not appear to have a major impact on the human environment, a government agency is required to conduct an environmental assessment, or EA, to determine whether further analysis is required. If it's clear that there will be a major impact, the agency is required under NEPA to conduct an environmental impact statement, or prepare an environmental impact statement, which is usually a very thorough analysis of the impacts. The FCC's radio frequency regulations were implemented in order to satisfy NEPA. Other agencies address health and safety issues outside of the normal NEPA process, but at the FCC, they put it within the context of the NEPA process. I should add that NEPA and the NHPA are process statutes. They do not require specific results. They only require an analysis. Typically, however, if undue environmental impacts are determined to exist from a proposed action, the NEPA and NHPA process will involve the development by the agency of mitigative actions that are intended to reduce the environmental impact. It's important to know, though, at the FCC, by regulation, most wireless facilities qualify for a categorical exemption from NEPA review unless they fall into certain categories, such as they're located in a wilderness area, or they might affect threatened and endangered species or their habitats. When I went to court and got the FCC's decision to exempt all wireless facilities from NEPA review overturned. That reinstated the existing NEPA regulations at the FCC, including these categorical exemptions for most wireless facilities. In 1996, Congress enacted the Telecommunications Act that significantly changed how communications companies were regulated. The intention was to introduce greater market competition into telecommunications services. This reflected a rapidly expanding service offerings created by new technologies. And because a significant portion of the population in the United States was thought to be underserved by telecommunications services, Congress sought to accelerate the deployment of advanced communications technologies. This has often been expressed as broadband for all. Accordingly, to the extent there is a concern over the health impacts and the safety of RF emissions, greater and greater numbers of Americans are going to be exposed as the FCC moves forward, or if the FCC is successful in moving forward with the rapid deployment of wireless technologies. Of course, there are vested economic interests involved in these activities. The 96 Act specifically preempts state and local laws in several respects, and I've given you the statutory site for the, there are some lawyers among you who may be interested in looking that up. Section 332 C7B specifically prohibits state and local governments from unreasonably discriminating among functionally equivalent services. It also prohibits them from having the effect in any action they take of prohibiting personal wireless services, and it regulates personal wireless facilities on the basis of the environmental effects of RF radiations. If the facilities comply with the agency's RF guidelines, they will be permitted. In other words, and they're self-certifying, so that there's virtually no oversight. In other words, as long as the company tells the agency that their phones and their towers and transmitters comply with the guidelines, they are going to be left alone, and it's up to opponents to demonstrate that they don't comply, which creates a significant financial burden on those who might intervene against the deployment of these facilities. The burden has been shifted totally on opponents of these facilities. This is true notwithstanding the fact that the 96 Act contains two quote unquote savings provisions that are intended to preserve local authority. One is a general savings provision to preserve local authority, and the other is a more specific provision that states that the act shall not be construed to even impliedly preempt local law. That is, the preemption must be expressed in the action undertaken. These savings provisions have not worked out to help really state and local governments preserve their authority. They have, in experience, been steamrolled, as we might say, by the drive of telecommunications companies to get their facilities deployed. As I address here, the limited value of the savings provisions in the 1996 Act does not override the preemption provisions in Section 332C7B and the savings provisions in the Section 601C1 only protects against implied preemption. The courts have determined that the federal authority can preempt for a number of other reasons, even if it's not implied, if it's expressed, or if it's established for other reasons. So the FCC has taken a number of actions to expedite wireless deployments. In 1996, in August, they adopted the current guideline, implemented, as I mentioned before, under NEPA. It covers facilities, but includes cell phones, which is an interesting wrinkle since some might argue that cell phones are not facilities and that therefore the FCC did not even have authority to adopt guidelines for cell phones. But that has been sustained apparently in several different court decisions, their authority over cell phone RF radiation. Some people have argued that the Food and Drug Administration in the United States has the principal authority over radiation from consumer devices under other legislation. That legislation, you may have heard Deborah mention it, but if not, that other legislation only requires the FDA, the Food and Drug Administration, to take action if they determine that it's necessary or reasonably necessary to protect the public. And the FDA is infamous, I guess you might say, in the United States for passing the buck on this issue. I won't go into that further at this time, but if you want additional resources on that, I'm happy to send you additional material. The 1996 guidelines that are currently in effect at the FDA are based on the 1992 ANSI guidelines. And as I mentioned before, many of these facilities are categorically exempt under the FCC regulations. And again, the FCC terminated an inquiry to update these standards in December 2019. The inquiry had begun after another government agency, the General Accountability Office, had issued a report in 2012, basically reporting that the guidelines were out of date. Nevertheless, the FCC has concluded that they're not out of date. They got some assurances from the FDA that they're just fine as they are, notwithstanding a wealth of data indicating otherwise. Then in March of 2018, in what's called the second report in order, the FCC excluded all small wireless facilities from NEPA and NHPA review. This is the decision I mentioned earlier that has been overturned by the U.S. Court of Appeals for the District of Columbia. And it reinstated the 1996 guidelines, still not updated. Other actions taken by the FCC include the September 2018 third report in order, clarifying that an effective prohibition, that is an action by a state and local government in violation of the 1996 Act, occurs whenever a local government agency inhibits a service provider from filling a gap in coverage or densifying a wireless network, introducing new services, or otherwise improving service capabilities. So you can see that by preempting all of those actions by a state or local regulator, the FCC basically is defanging the state and local agencies from any relevant authority. The third report in order also establishes standards for when and how local authorities may base permit decisions on aesthetic impacts. It states also that minimum spacing requirements would likely be considered unreasonable. So telecommunications service providers, therefore, basically have unfettered discretion as to co-location of transmitters on facilities and on the ground adjacent to facilities. Okay, well, I was trying to speed it up. There are also shot clocks, 60 days for new facility, for existing facilities, 90 days for new facilities for local government action. They only have that long to act on applications, or it will be interpreted as a violation of the law, and the telecommunications company can go to court and enforce the plan to deploy facilities over the objections of local authorities, irregardless of the local opposition. So the results of the FCC actions have largely overtaken the authority of state and local governments. Health and safety standards are outdated. They're not up to dealing with current technologies, and federal environmental reviews are not being adequately enforced. Now, the only legal strategies at this point is to abandon local enforcement efforts in most cases, unless there's a express misrepresentation of safety by the telecommunications company, as in the Apple and Samsung litigation that Dr. Arazi referred to previously, where they're accusing the companies of misrepresentations. If there's no misrepresentation, if the company just remains silent about the safety of its equipment, except to say it's compliant with the federal guidelines, the action would have been preempted. So the only way to deal with this is to challenge the FCC in its haste to expedite the deployment of wireless technologies. Challenges of cell phone companies at the local level are not likely to be very availing in most cases unless there's a misrepresentation. Challenges can be based on the requirements of NEPA, the NEHPA, and the overall requirement for reasoned decision-making in the Federal Administrative Procedure Act. We had a success story, as I mentioned earlier, in overturning the DC Circuit on the decision to eliminate NEPA and NHPA review in 2019, where the court found the FCC's decision was arbitrary and capricious. There are pending court challenges. There's oral argument today, as a matter of fact, in the Ninth Circuit on the third report and order. And the FCC's decision to terminate the notice of inquiry is on appeal by the Environmental Health Trust, currently in the DC Circuit. And as we mentioned previously, Apple is the defendant in a case in California, challenging the company for having misrepresented the safety of its cell phones. Any questions? I'm happy to answer. Sure.
The floor is open for any questions. Do we have a question? Okay. So if I can sum up your talk, Edward, you're basically telling us that the FCC has effectively stopped any challenge by local authority to any deployment whatsoever for the cell phone industry.
There are still efforts underway by folks around the country to stop them at the local level, but it's very difficult. There's some basis for challenging on aesthetic grounds, but challenging for safety is very difficult unless you can demonstrate that the facilities do not comply with the federal guidelines, which requires a substantial technical effort to monitor the towers, the transmitters, as they operate.
I see. Okay. If there are no other questions, then I'd like to thank the speaker once again. And
Welcome.
Edward, if you could stop sharing your screen, we'll move to the last speaker of today.
Okay.